I want to talk about some recent headlines and connect some dots that I think are really important for us to understand, especially as you see around all the fanfare around the country's 250th anniversary. I want to connect comes from the Supreme Court. The Supreme Court released a slew of decisions in the past week. One of them shielded Roundup from lawsuits, failure to warn lawsuits in state court. Basically, people are saying, hey, these products that Roundup is selling have carcinogens, have cancer causing elements in them, and they don't warn people about that. And it causes, obviously, cancer, right? Life altering, life threatening diseases. And the state requires you to notify people when you're using certain ingredients. And essentially, the Supreme Court says, yes, that state might require it, but the federal law doesn't, and the federal law preempts it. The details are not as important as the outcome. The second case that the court released was one. Um, Basically upholding the revocation of temporary protected status for Haitian immigrants. This is kind of a big part of what set up the stage for Trump's anti-immigrant campaign 2.0, right? The first round was during his first administration, and it was the anti-Muslim ban. But this round, when he started talking about Haitian immigrants eating pets, we kind of knew where this was going. He eventually revoked their temporary protective status, and that was the case. It was before the Supreme Court, and the Supreme Court upheld his revocation. And this is the progeny of Che Champing. It's the progeny of Chomp v. Hawaii, which was the Muslim ban case, basically where the judge or the court has said judges are not in a position to review security decisions from the executive. The executive is responsible for keeping the country safe. They have information, access to information we don't have. We are not in a position to assess whether or not their judgment, their decisions about who is and who is not a security threat to the country are valid. So if they say Haitians are a security threat and can't come in the country, then we have to defer to their judgment, was basically the thrust of the opinion. One of the other headlines that I saw was companies that spent some upwards hundreds of millions of dollars lobbying on the past election cycle have paid nothing practically in taxes. And then the other headline that I wanted to point out was one coming out of Texas. A farmer had donated, I don't know, 100 acres maybe to the city, with the stipulation that the city used that land for a playground for children, and instead it was sold to um, AI data center. The founding fathers are this country's original oligarchs. The founding fathers, Thomas Jefferson, George Washington, James Madison, all slaveholders, are the country's original oligarchs. They crafted the Constitution. They are its drafters, right? Alexander Hamilton. No, he did not personally own slaves, but he married into a slaveholding family. The Schuyler sisters were huge slaveholding. And he despised the common man. He was a huge advocate for corporate power, for corporate political power. And so the founding fathers are the country's original oligarch. And they crafted a constitution for oligarchs. That's why the 1787 text doesn't have a whole lot of protections in it for anyone. It's not meant to be a document that's protective. It's meant to discuss the organization of the government. It's meant to discuss processes, procedures. It was supposed to be an organizing document primarily, but the protections that are included in there are for corporate power. The document for the people, by the people. The people are the sovereign. They believe in popular sovereignty, and it's meant to be governed kind of collectively in this democratic participatory way, albeit with limitations on who gets to vote. Then why is the only thing that gets power in the core text of the document corporations? How does corporate power get protected first if it's for the people? Unless it's not actually for the people, that's just the way it's been marketed to you through your education, through your media, through the talking points of your politicians. They want you to believe that you're empowered so you're less likely to rise up and actually take power. You have a group of people who were very wealthy, who had to use their personal wealth to finance a revolution. Because colonies did not have a navy. Colonies did not have ammunition to defeat one of the most formidable empires in the history of the world. They had to borrow that stuff from other countries. Well, why would other countries be interested in pissing off Great Britain to help out a bunch of colonies if they wasn't getting nothing out of the deal? The colonies promised them either enslaved people as collateral or the harvest from enslaved people as a collateral or credit worth both, right? And they knew both the colonists, the framers, and the countries that they were attempting to solicit help from. Our entire banking industry depended on the slave trade. And so they knew that slaves functioned as a currency of the world, a good currency that they could rely on enough that they were willing to lend colonies, 13 colonies who wanted independence from Britain, enough of an army to do so, enough of a navy to do so, enough ammunition to do so. In exchange for lending you my enslaved people, in exchange for putting my crop up as collateral, I'm getting something. What did Denzel say? I'm leaving here with something. And that something was I get to come to the Constitutional Convention. Fully between a third and half of the delegates to the Convention were either slaveholders themselves or deeply invested in the industry of slavery. They were at the Constitution. They got to draft the Constitutional Convention. They got to draft the document. They got to make arguments on its behalf, both to the public and to each other. These people got to play a sizable role in the government because the government needed funding, it needed capital. That capital was black people, but those black people were owned by enslavers. Those enslavers said, yeah, I'll put them up as the capital, as the down payment on the country if I get to shape it, if I get to make sure that my business, the very business that's funding this thing, is protected. So it's no surprise that they wrote in Article 1, the slave trade clause, that, yeah, okay, you the people, you get congressional power, you get plenary power over war and over commerce and blah, 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 blah. But you can't stop the importation of enslaved people. Even the Corwin Amendment on the eve of the Civil War was basically attempting to take the question of slavery out of congressional power. Who can do that? What people who are supposed to be the sovereign would give up the power to regulate something that's supposed to be in their ambit, that's supposed to be within their purview, per the document that created them? It happens when you have oligarchs controlling the government. Fugitive slave clause. There was no precedent for that in international law. It was a case in Britain where an enslaved person, I believe, had escaped from Philadelphia, had gone over to London, escaped while he was there. His master managed to find him. His master managed to find him and demanded that the court extradite him, basically order him back to the United States. And the court in the UK was like, we don't have no precedent for that. There's nothing in international law, there's nothing exists in law anywhere that says if an enslaved person escapes, they must be returned. Why would we create that? They put it in the Constitution. After that case, when the colonists were drafting their own constitution, they was like, we're gonna put it in our constitution. Since it doesn't exist in international law anywhere, since there's no precedent for it, we're gonna create the precedent. We're gonna create a precedent that says not only are they to be ordered back to us, but the federal government must assist us in doing so. How are these private corporations, these private oligarchs using the federal government on their behalf to hunt down their property, to ensure their profits, unless they crafted it because they had an outsized influence over the document? And that's even before we get to the Three-Fifths Compromise. So you have the slave trade clause, you have the fugitive slave clause, and you have the Three-Fifths Compromise that are all protections for corporate power. It just so happens that that corporate power is in the form of slavery. And in this country, slavery is mired in so much racial shame. We think about it primarily as a system of racial power, but the people who were crafting it did not. The people who were crafting it thought about slavery primarily as a business, as an economic enterprise, as an economic endeavor. And so the standards that they created for corporate power, even when slavery was abolished, obviously air quoting, the precedent for protecting corporate power, for allowing corporate power to be at the forefront of political power and to drive our political agenda, to influence policy, was never disavowed. It never went anywhere. It was not abolished with slavery. So when you see the Supreme Court comporting its decisions with that sentiment, it's not wrong. It's just that we have an erroneous understanding of the Constitution, who it's for, and what it does, and we can't fix this with new justices. This was Justice Powell. This was the 14th Amendment. The 14th Amendment has been far more protective for corporations than it has for people, especially Black folks. And that's to be expected in a governance regime in which corporations are at the forefront, because corporate power had an outsized hand in crafting the Constitution in the first. Their interests were centered in the Constitution. Their interests were centered in the document. The document was drafted by them for them. That's why all of the rights that you associate with the Constitution that are reserved for individuals, the civil liberties, had to be amended and added in later on, years later, They were not at the forefront of the people who were drafting its mind. That's why they are not in the 1787 text, because those people were oligarchs. What were they interested in protecting? Their business. So what did they write in protections to the Constitution for? Their business, which at the time happens to be slavery, but it could be any business. It could be the tech oligarchs. So when you see the Supreme Court guarding corporate interests, favoring corporations over people, favoring the profits of corporations over people's lives, they are not deviating from the Constitution. They are enforcing it. You've just intentionally been misled about, what it's for, who it's for. Because if you weren't, if people really understood that this country is organized on behalf of businesses by businesses, and I don't mean this in some abstract conspiracy way, I mean this in that this is the shit that the document says. People would be much more hostile to the system and thus much harder to manage. And so you're upset with the Supreme Court. You don't need new Supreme Court justice. You need a new system. You need a new institution that doesn't allow corporate power to wield this kind of political power and doesn't put a bunch of unelected, lifetime appointed judges up there to gatekeep that power.